It's Saturday, November 25th, and you're watching Velshi on MSNBC. I'm Charles Coleman Jr., filling in this weekend for my friend and colleague, Ali Velshi, and we have got a lot to talk about. First off, we're following breaking news this morning on day 2 of a fragile pause in the war between Israel and Hamas. NBC News is reporting 13 more Israeli hostages are expected to be released today by Hamas. 42 Palestinian prisoners are also expected to be released as well, according to Israel's Channel 13. We are awaiting word on when this exchange is actually going to happen. If it is successful, it will be the second batch of hostages and prisoners released by the two countries as part of a deal that involves a 4-day pause in fighting. Over the course of these 4 days, Hamas has agreed to release a total of 50 women and children that were taken hostage during the October 7th attack. Now, in turn, Israel then agreed to release 150 Palestinian women and teenagers that it has detained. As soon as we know when these exchanges are taking place, we are going to bring it live to you and let you know. Our coverage of this exchange will take you there with pictures and reporting from our NBC News team on the ground in Israel, and we will check in with them in just a few minutes. But first, let's get up to date on the multiple trials of Donald Trump, where new developments this holiday week might have slipped under the radar. To start off, there are ongoing legal battles over a pair of gag orders against the former president. Now, in a new brief opposing the temporary pause of the gag order in the civil fraud case in New York, a court official with the Judicial Threats Assessment Unit detailed the torrent of harassment that Judge Arthur Engoron and his law clerk had been receiving. Now, let me say this again. The Judicial Threats Assessment Unit. If you've never heard of it, consider that a good thing. But it is, and it does, just what it sounds like. Assessing threats to judges and clerks and other court employees to ensure their protection and their safety. And now they're being called in no small part, because the former president of the United States can't seem to resist the urge to attack those who are simply doing their jobs while he's on trial. Let that sink in for a moment. The brief, filed by the state attorney general's office, noted that the clerk's personal cell phone and emails have both been compromised. And as a result, quote, she has been subjected to, on a daily basis, harassing, disparaging comments and anti-Semitic tropes, end quote. The court official added that the threats, quote, considered to be serious and credible and have not hypothetical or speculative, end quote. Now, this filing includes direct quotes from some of those messages, most of which I can't even say on television because practically every word is a curse, and my mother watches, and I like my job. Not to mention that the FCC is very good at theirs. The gag order in New York is actually being paused until Monday, when judges in the New York Appeals Court are going to reconsider the issue. But what's happening here is the kind of harassment that prosecutors down in Washington, D.C. are also trying to prevent in the federal election interference case against Donald Trump. In fact, prosecutors sent that very same brief filed in New York to the D.C. Court of Appeals as part of their own bid to get the gag order in the case reinstated. This past Monday, judges at the D.C. Court of Appeals signaled that they were open to keeping a narrower version of the order in place, but they have yet to issue a final ruling. Meanwhile, there are growing concerns that a Florida judge is slow-walking the classified documents case, and that this same judge perhaps is opening the door for the trial to be delayed. Now, if you've been keeping score, yes, this is the same judge who happens to be a Trump appointee. And it's the same judge who got reversed on appeal after she performed some legal somersaults, essentially trying to stretch the law in response to the contours of a special master in the same case way before the DOJ had even finished its investigation and indicted the former president. And yes, this is the same judge who pushed the trial date for this same documents case way into May of 2024. Now, even with that May 2024 date still technically looming on the calendar, critics have pointed out that Judge Eileen Cannon has been taking her sweet and slow time deciding on the motions and has also postponed some key pretrial deadlines. Now, the concern with all of this is that it could add up and ultimately result in the trial being pushed back even further beyond what might be the 2024 presidential election date. Joining me now is Danny Savalas, a criminal defense attorney and an MSNBC legal analyst. And of course, also with us is Anthony Coley. He is the former director of public affairs at the Department of Justice and the former chief spokesperson for Attorney General Merrick Garland, and also an MSNBC justice and legal affairs analyst. Beyond the titles, these are two of the best people I could be talking to. I see my man in the maize and blue. This is a big day. I don't want to spend too much time about the rivalry, but you
First of all, Charles, it's a testament to how much I love Charles Coleman that I'm even here on the day of the Michigan-Ohio State game. If that Ali Velshi had asked me, I would have told him to be. We're pre-taping right now, right?
No, this is live. This is live. Yes, indeed. Good luck to you guys today. But since you are on a time crunch, let's go ahead and get started. I'll start with you, Danny. You know, it seems like, and I'm taking the glasses off because this is straight lawyer talk here, that judges are starting to make a very direct connection between the posts on social media that the former president is engaging in and the response that he's getting from his followers, and seeing that as a real threat. I'm going to read for you a quote that came out of this hearing in D.C. this week. It says, one of the judges asked, why does the district court have to wait and see and wait for the threats to come rather than taking a reasonable action in advance? Do you think that judges are really starting to sort of dismiss the arguments that have been made by Donald Trump's defense team about some of his social media activity?
Never before has any court had the challenge of gagging a defendant like Donald Trump. Because, as you know, Charles, for the vast majority of criminal defendants, if they criticize the judge, if they criticize the prosecutor, nobody cares, because it's not even remotely political speech, and nobody, for the most part, is listening. Maybe they have a couple hundred followers on Twitter. Who cares? This has never happened before, where you have a political figure who is making the argument that everything he says, as ridiculous and offensive as it is political speech. And there's another layer of complexity, which is this. Do we curtail someone's First Amendment rights based on what other ill-advised, stupid people do in response to what that person says? Because when you look at his words alone, they may not incite riot, they may not be a call to action or a call to violence, but other misguided people will take it as such. So how do we deal with that constitutionally? Do we hold Donald Trump responsible for what those people do idiotically? And do we curtail his First Amendment rights? This is a rhetorical question. I don't know the answer, and I don't know that the courts know yet either. This has just never been dealt with before.
Anthony, speaking of social media and posts, you were on social media this past week, and you were talking about the notion that basically what Donald Trump is doing around these gag orders and how he's responding is an attempt to control the public narrative.
Right.
I tend to agree with you, and I've been saying that along with a lot of other people for a very long time. My question to you is, how successful do you think he is being with that ploy?
Yeah, he's been very successful. I will break it down. I'm not the lawyer, as both of you, so I'll speak,
Listen, you're grandfathered in because of your time at DOJ, so it's all right.
So here, let me break it down. Trump is playing dirty. He knows full well that anytime he attacks these lawyers, these prosecutors, these judges and their staffs, he knows that many of his followers view these things as marching orders. And there's a pattern of it. I remember in September of 2020, he is asked specifically to condemn violent right-wing extremism. He demurs and he tells the Proud Boys, you know what he says? Stand back and stand by. In December of that year, he tells people, he summons them to Washington, D.C., and he tells them, come, we'll be wild. And then they show up on January 6th. And I went back and I read the transcript of his remarks. The word fight or fighting is mentioned 20 times in that transcript. He tells them to fight like hell. You know what they do? They go down to the Capitol and they fight like hell. And they only stop when he tells them to stop. So there is a clear correlation between what Donald Trump says and what his supporters do. And my hope is that the court recognizes that quickly because people's lives are at stake here. And that is not hyperbole.
Now, I want to follow up with you. Yeah. You're the messaging guy. You're the communications guy. We're the lawyers. I think that a lot of people don't realize that for Donald Trump, in terms of him pushing the narrative, there is a space where it's heads I win, tails you lose in terms of how he can control the narrative from purely a messaging standpoint. I'm talking about the technicality of it, not the quality of it or its substance. I'm talking about, the overall outcome that he seeks to advance. Is it a good idea?
So there are two things here. Number one, I think he has this two-track objective. He's trying to delay these cases for as long as he can. That's especially true with Judge Eileen Cannon, and we're going to talk about that, I hope, in a little bit. But the other thing, what he's trying to do is to change public opinion, to influence what happens inside the courtroom, to influence what happens inside the court of law. Remember, he really only needs one member of a jury in any of these cases to say not guilty. And so what is he trying to do? He's trying to intimidate witnesses. He's trying to poison the jury pool. That's his goal here. And I would say, just from my observation, both of these things, his political campaign and his legal woes, they're all intertwined here. And I think that's what he's trying to do.
Now, Danny, Anthony has told us we need to move on to Eileen Caney, so let's just do that.
Yep.
As attorneys, we are looking at this trial calendar, okay? And delays are not necessarily, unusual. It's something that happens. People are arguing that Eileen Cannon seems to be setting the stage to push this as close to or beyond election 2024. What's the likelihood that happens?
Very likely. I've said that as to most of these cases, especially the state court cases, you can plan on 2025 for trial to start. When it comes to the Fulton County case, first witnesses in 2025. Save the tape. I've said it before. Don't save the tape, just in case I'm wrong, but save it so I can say it now. The point is that these cases are going to take a while. These are the most significant criminal trials in American history. And while the government, at least in the documents case in Florida and in the D.C. case, they may feel that they're ready to proceed for trial, absolutely the D.C. case is designed for speed. That will probably be the first one to go to trial. The documents case is complex. The government says they can proceed to trial sooner. Yeah, but as a defense attorney, the government is usually pretty ready by the time they indict the case. It's the defense that has to look through terabytes of documents and decide how to proceed, what kind of defense they want to put on. So I am a little sympathetic with the idea that this will take some time. But at the same time, federal court generally moves very quickly. I think the May 20 trial date in the documents case in Florida is probably not going to happen. In my experience, what federal judges do, because they have so much pressure to move cases along, they'll set a trial date that may not be realistic, and they leave it to the parties to make a motion and ask them to move it. That way, the judge has done his or her job, and the parties can fight over whether or not that's a good trial date. And believe me, they are going to fight about it because the government has made the case, and I think it's a credible one, that even though these are complex issues, the documents, there are different tiers of classified and more sensitive, less sensitive documents, they still think they can go to trial sooner rather than later. But the defense is going to make a lot of arguments, some of them reasonable, some of them stretches. That's our sworn duty. You know that, Charles, as defense attorneys, as long as we're zealously representing our client within the bounds of ethics, we are duty bound to try everything we can. And the reality is delay in this case, delay usually inures to the benefit of the defense, but never before in American history has delay inured to the benefit of a criminal defendant like it will for Trump, because if this case is still pending, any of the federal cases, he'll simply appoint an attorney general who will dismiss it. If that doesn't work, he will try, may not be successful, will try to pardon himself.
But Anthony, I want to put you back in your former role really quickly. We haven't heard much from Jack Smith, understandably so, and we haven't heard much from Merrick Garland. The closer that these trials get pushed toward an election, would you advise either of them to say something publicly about the need to either hold off or the need to press the gas? And if so, which one?
Yeah, so I don't imagine them to say anything outside of the court of law. Listening to you talk about this is really interesting, because my takeaway is that Judge Eileen Cannon in this case, she feels like she's a referee who's trying to rig a game before it even starts. That's how I view this. But the fact of the matter is that the evidence in this documents case is so overwhelming. We're not talking about, George, something that a witness may or may not have overheard secondhand in a coffee shop. We're talking about here solid evidence, firsthand accounts from people who were in Donald Trump's employ with photographic evidence, with videotape from Mar-a-Lago. The government's case here is airtight, and I would note that they are really successful in winning these types of cases up to 95% of the time.
Yeah.
More than 90.
Right.
The federal
Right.
government is deadly efficient.
Right.
This is a big deal. So much we could have talked about, but I appreciate you guys joining me. Danny Savalas, Anthony Coley, getting us started today. Go Blue.
Go Blue indeed.
Still to come this morning on Velshi, a second group of hostages is expected to be released today in exchange for a group of Palestinian prisoners being held by Israel. We'll head to the region for the very latest. Stay tuned. You're watching Velshi right on MSNBC. Welcome back. You're watching Velshi on MSNBC. I'm Charles Coleman Jr., in for Ali Velshi. We continue our coverage in the Middle East, where a second group of hostages is set to be released today in exchange for another group of Palestinian prisoners. The situation is very fluid, so the timeline of today's expected swap and the number of hostages expected to be released are still unclear. But we are following developments closely. You're taking a look right now outside of the Ofer prison, an Israeli prison in the West Bank. Now, this is where Palestinian prisoners are expected to be transferred from. Reuters is reporting at least one empty bus is sitting outside the prison, getting ready for the transfer. Yesterday, 13 Israelis, as well as 10 Thai nationals and one Filipino, were released in exchange for 39 Palestinian prisoners held in Israel. Another result of this deal has been a 4-day truce between Israel and Hamas. Since yesterday, there's been quiet over the Gaza skyline for the first time in 40 days. This comes as Israel halts its brutal military campaign to allow the hostage swap and the flow of aid into Gaza. Yesterday, the hostages were transported by the Red Cross from Gaza to the Rafah crossing in Egypt. There, they were flown to hospitals in Israel to be examined and reunited with their families. Involving U.S., Israeli, Qatari, and Egyptian officials, and some even personal intervention from President Joe Biden. According to a senior Israeli government official, Biden spoke to reporters from Nantucket after the first hostages were released yesterday.
I've consistently pressed for a pause in the fighting for two reasons: to accelerate and expand humanitarian assistance going into Gaza, and two, to facilitate the release of hostages. And over the past several weeks, I've spoken repeatedly with the Emir of Qatar, the President Sisi of Egypt, and Prime Minister Netanyahu of Israel to help secure this deal, to nail it down.
Joining me now is Aaron McLaughlin, a NBC News correspondent in Tel Aviv, and Dave Noriega, an NBC News correspondent currently located in Ramallah. Aaron, thank you for being here. Let's start with you. What can you tell us about the hostages that are set to be released today? How many are they? And what's the timing that you're looking at?
Well, Charles, this time yesterday, Hamas was just minutes away from handing over 13 Israeli hostages to the Red Cross. Today, we've had no news so far. The schedule for today's exchange has not been made public. We know from a diplomat with knowledge of this process that they expect at least 13 Israeli hostages to be handed over to the Red Cross and brought over the border into Egypt and then into Israel today. But the Israeli government is not releasing the names that are expected to be released because this is seen as an extraordinarily fragile process. Meanwhile, you have more than 200 families of the hostages remaining inside Gaza, waiting and watching to see what happens next. I was speaking to one man who has relatives still inside Gaza. He told me that his family is not on today's list. They have been informed of that, but he's hoping. He said that with every release, there is new hope for the next release and the next release. Remember, this is at least a 4-day ceasefire, Charles.
Now, David, you're in Ramallah, where people were actually celebrating the other side of the deal, that being the freed Palestinian prisoners. What has the Palestinian reaction been to this deal and this prisoner exchange?
Yeah, Charles, from here in the West Bank, the reaction has been one of celebration and jubilation, although some of that has been tempered by some of the realities of the occupation. The organization that represents Palestinian prisoners says that the released prisoners and their families have been warned by Israeli authorities not to have large public gatherings to celebrate the releases, not to speak to the press, and that if they do, they may be fined up to about $20,000. That said, last night in Ramallah, when this first group of prisoners was released, we spoke to several Palestinians who had gathered there for the occasion. Several of them said that they were hoping this exchange would lead to something greater. We spoke to one human rights attorney. Here's what he had to say on the matter.
For me, it's a hope to see that now there is swap prisoner. There is a free that people are getting there free, and this is like a start for me for something big. That I hope that this will lead to end this occupation.
Charles, ultimately it's not up to people like him whether this pause in the hostilities leads to a final peace. It's up to the parties in question. It's up to the IDF and it's up to Hamas. So for the time being, the best they can do is hope. Charles?
That was NBC News correspondents Aaron McLaughlin and David Noriega. Thank you to you both. We will continue this conversation with someone who led the U.S. government agency in charge of bringing American hostages home. That's next. Stay with us. There's more Velshi on MSNBC on the other side of this break. Welcome back to Velshi on MSNBC. I'm Charles Coleman Jr., sitting in for Ali Velshi. We're watching and waiting for developments this hour from Israel, where a second batch of hostages and prisoners are expected to be exchanged between Israel and Hamas. Joining me now to talk about this process and what we can expect next is Christopher O'Leary, former senior FBI official and former director of hostage recovery for the United States. Mr. O'Leary worked in counterterrorism for more than 2 decades, and most recently he ran the Hostage Recovery Fusion Cell. That's a task force that's dedicated to the rescue and recovery of American citizens taken hostage by terror organization. He was in that role up until just a few weeks before Hamas attacked Israel on October 7th and took more than 200 hostages, including at least 10 Americans. Chris, thank you for being here. Good morning. I want to start because there are a lot of Americans who are concerned that the Americans who have been taken hostage are not being released or have not been released at this point. Is that a reasonable expectation? What do you say as someone who's...
If you're new to this channel, please support by hitting the subscribe button. Also, please ensure to hit the bell button so you'll be the first to know when I drop a new video. In the field of legal disputes involving public figures, every step of the courtroom is important. The risks are high and the wrong move can have major consequences. Donald Trump, a polarizing figure, is no stranger to legal trouble, but his recent missteps in court have refocused attention on the effectiveness of his legal defense. At the heart of the dispute is a serious legal malpractice that occurred at a critical stage of the proceedings. The error, caused by a mistake by one of Trump's most prominent lawyers, drew attention not only for its immediate impact but also for its potential long-term impact on the trajectory of the legal battle surrounding the former president. The basis of the legal error is the non-compliance with the submission deadlines essential to the case. There are strict deadlines for court proceedings, and failure to meet these deadlines can have serious consequences. The failure to provide surveillance, key documents or evidence by the deadline has raised questions about the training and effectiveness of Trump's legal defense team. As legal experts examine the implications of this error, one of the main concerns is how it will affect Trump's overall defense strategy. Deadlines for submitting documents are not arbitrary. It is an essential part of a structured litigation process. Failure to meet these deadlines could weaken the defense's position, allowing the other side to exploit gaps or weaknesses in their argument. The public opinion of Trump's defense team is not exempt from this grave error. Especially where public figures are involved, transparency, competence, and compliance with procedural requirements are important elements of reliable legal protection. The courtroom inquiry has captured the attention of legal experts and the general public alike, raising questions about the integrity and effectiveness of Trump's legal representation. This mistake will force Trump's legal team to limit the damage and respond strategically to the situation. This includes not only eliminating immediate consequences, but also implementing measures to strengthen future defenses. How the legal team handles this mistake and learns from it will be important in shaping the narrative of Trump's legal battle. Litigation is complex, and even the most experienced attorneys can face challenges. The ability to recognize and correct errors is a sign of permanent legal protection. Now is the time for Trump's legal team to learn from this oversight and take corrective action to maintain the credibility and effectiveness of his defense strategy. Donald Trump, characterized by a serious mistake in court, represents the delicate characteristics of disputes with tall people. When legitimate soldiers are exposed, the result of this control will continue to form public history and reception. Whether the defense can recover from this significant error, take corrective action, and effectively manage future legal challenges remains a central question in the unfolding story of Trump's legal journey. John Sauer, who is representing Trump in a federal election interference case, spoke Wednesday before a three-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit. He argued that the ban imposed by Judge Tanya Chutkin violated Trump's First Amendment rights and was too broad and vague. But Sauer faced tough questioning from jurors, who repeatedly interrupted him and questioned his claims. At one point, Sauer tried to speak to Judge Patricia Millett, who asked her if she agreed that Trump's comments about impeachment special counsel Jack Smith were false and defamatory. Sauer said he disagreed, but Millett chimed in, saying, "You can't talk about me." He then asked him to answer his question directly, but Sauer said he didn't want to. Renato Mariotti, a former federal prosecutor and CNN legal analyst who attended the trial, told Newsweek that Sauer's actions were a big mistake and showed disrespect for the court. He was very aggressive and argumentative with the jury, which is not a good strategy, Mariotti said. Thanks for watching this video till the end. Please subscribe to our channel.